Greetings from Jerusalem. Welcome to this special ICJ webinar, and thank you for taking the time to join us. This is a special session which is organized together with the Israeli Ministry of Foreign Affairs and the Hague Initiative for International Cooperation from The Hague, the Netherlands. We are going to speak today about the recent decision of the International Criminal Court, which could possibly open the way and allow possible war crimes probe against Israel. Even though the decision at hand is an answer by the pre-trial chamber to a procedural question regarding jurisdiction, which was brought forth by the special prosecutor, and this decision does not automatically imply the opening of an investigation against Israel. Nevertheless, we consider this decision outrageous, and we believe it calls for a reaction. And this is why we decided to hold this seminar, and this is the first of a two-part webinars devoted to this matter. The second one will be held in exactly 1 week from now, on Thursday the 25th, at the same time, 5 p.m. Israel time. And today, we will explain the importance of the issue and provide some background information about the role and the powers of the International Criminal Court. And of course, we will hear Israel's assessment of the situation, how dangerous it's potentially to the state of Israel. And our intention is together to consider possible avenues of action. And based on the results of today's discussions, we're going to come up with some specific proposals next week. So please be sure to join us again next Thursday. Today we have 3 speakers. Each will give about a 15-minute presentation, and then we will open the floor to questions and comments. We have several distinguished panelists among us. They can be seen on the screen, and they will have the priority in expressing the comments. And then, in addition, anyone from our international audience, and I would like to welcome you all. We have about 80 people who registered for this webinar. So all of you can ask a question by simply writing in the chat. Subject to time limitations, we'll try to give the floor to everyone. So without much further ado, I'll give the floor to the first speaker, who is my colleague at the International Christian Embassy, the Vice President and Senior Spokesman, David Parsons. David is a lawyer by profession, has been following current events in Israel for decades. He is also a writer and a Middle East specialist, and also one of the co-authors of the US Congress Jerusalem Embassy Act, which was passed way back in 1995. It provided for the relocation of the US Embassy to Jerusalem, which finally happened, as we saw, under the administration of President Trump. So David, please start and explain to us what this decision and the ramifications are all about.
Thank you, Mormir. I want to give a little context and background to this recent ruling by the International Criminal Court, why not only Israel, but all her supporters around the world, especially us Christian supporters, should take this seriously, and then allow the professionals who deal in international law every day, Amit Human from the Ministry of Foreign Affairs and Andrew Tucker from Think in The Hague to build on the background and knowledge we need in order to fight this. But the Christian Embassy has been monitoring this over recent years, and looking at this ruling, we've decided to really come out using our international network and working with other friendly organizations, respected organizations, to oppose the International Criminal Court's recent ruling to unlawfully extend its jurisdiction so that a war crimes probe could be launched against Israel. We see this as a highly selective and biased move, which has stretched international law beyond recognition and even opened up the court to justifiable accusations of anti-Semitism, as was recently suggested by Israeli Prime Minister Benjamin Netanyahu in his response to the ruling. And we can first say that this ruling is absurd on its face. The jurisdiction of the International Court, as we'll learn from the experts here, it is a court of last resort. It is somewhat consensual. And if you're not a member of the state, you're not supposed to, and you also have serious proactive judicial mechanisms in your own country that deal with some of these crimes that are being mentioned, then you shouldn't be bothered by it. And Israel is not a member of the Rome Statute that governs the ICC, and it does have a very active and respected judicial system, including in the military, to deal with some of the crimes they want to look at, or alleged crimes, should I say. In addition, the Palestinians do not qualify as a sovereign state under the Rome Statute governing the court, and therefore the court had no legal standing or authority to investigate and charge Israel with war crimes in the so-called occupied territories. And I think what we're witnessing is an overzealous chief prosecutor bending international law to empower her quest to indict Israelis on invalid and unsustainable charges. We'll look at this in just a minute. She's been working on this for a while. It's fortunate that she's going to have to step down in June. Her 9-year term is over. But when we look at this, the reason it's so biased, the ICC is overlooking daily war crimes being committed by other brutal regimes, such as Iran and Syria, against their own people. And instead, the ICC is seeking to prosecute Jews for building balconies on their homes in East Jerusalem as if they were Nazi war criminals. This is why it's so outrageous and something that we really want to step up our actions against it. This ruling did not happen overnight. I believe it's part of a wider Palestinian diplomatic agenda that has been building since the 2001 Durban conference to delegitimize and dismantle Israel. And in terms of the ICC, it has been building for 5 or 6 years during the term of this chief prosecutor, Fatou Bensouda. And we'll look at this timeline in just a minute. But it does reflect the access and influence which the Palestinians and their global allies have in United Nations organs. And sadly, they have a large, effective network of pro-Palestinian NGOs and human rights groups, which constantly pressure these UN bodies to take actions against Israel. And I'd have to add with regret that this network is often funded in large part by other member states, like the European Union puts a lot of funding into some of these groups that are constantly agitating against Israel. And the ICC ruling represents a significant advance on 3 key prongs of this Palestinian agenda since Durban. And I'll share my screen here so that we can look at these one by one very quickly. Okay, first, they have been seeking to gain recognition of a Palestinian state outside of direct bilateral talks with Israel. We've seen this over and over again, going to the General Assembly for statehood. It requires approval by the Security Council, so they've tried there. That was blocked, but they've been able to get observer status in a lot of UN organs, even recognition as having a state in some of these UN forums. And now, according to this pretrial ruling by this 3-judge panel at the International Criminal Court, they do see that there is a Palestinian state in what they call the 1967 territories. That would be Gaza, West Bank, and East Jerusalem. And therefore, it's another significant advance in the Palestinian bid to bypass Israel in gaining universal recognition of a Palestinian state without having to make the compromises with Israel needed for peace. Number 2, they seek to undermine Israel's legitimacy and in particular, its right of self-defense. This was one of the key agendas coming out of Durban, the whole delegitimization, demonization, and dismantling of Israel, as some called it, the 3Ds. But we've seen a specific fight to try and strip Israel of its right of self-defense. And this move in the International Criminal Court would even allow the international community now to go back and look, especially at what happened in the Gaza conflict in 2014. It was the third Gaza rocket war. I imagine they would wind up looking at all three of the rocket wars in 2009, 11, and 14. Also the march, what they called the March of Return, which were really violent protests along the Israel-Gaza border in 2018. And they're wanting to identify and try Israeli leaders, political leaders, and military leaders on charges of war crimes, crimes against humanity in these incidents. There's also a certain peg about Palestinian prisoners that is involved in this. But once again, it's part of an agenda that if Israel is not legitimate, then they do not have a right to defend themselves. And this is all a battle of trying to strip Israel of the right to defend themselves against rockets, against terror tunnels, against terror attacks, against any means of attacking it. And third, the Palestinians are seeking to uproot the Israeli communities in Judea, Samaria, and we have to add East Jerusalem to this by discrediting them, delegitimizing them, and now even criminalizing settlement activity. And of course, there has been slow incremental progress in this and other UN organs. One of the most serious milestones in this effort, the dark milestone of the UN Security Council Resolution 2334 in December of 2017, as the Obama administration was leaving office. They not only refused to cast a veto against this resolution, but there's credible reports that they helped arrange it. But this is a very bitter resolution against Israel that decreed that the Israeli settlement activity is a flagrant violation of international criminal law. And what the ICC, at least this chief prosecutor, is trying to do is to turn settlement activity into a criminal activity, to actually say it's a war crime, similar to what, this is part of the Geneva Conventions, which were enacted after the Second World War and after the Holocaust. And these conventions on warfare were trying to aim at some of the atrocities committed by the Nazis, particularly against the Jews, including the mass forced transport or transfer of populations in and out of an occupied territory. And this was declared a war crime, a crime against humanity. Afterwards, part of the Geneva Conventions, it's banned under it. And what they're trying to say is that the Jews moving into the biblical heartland of the Jewish homeland here in Israel, and including in Jerusalem, that this is not only a violation of international law, it is a crime. That if someone in East Jerusalem wants to build a balcony on their home, a Jewish person, they are committing a war crime as if they were Hitler. And this is outrageous to us, and we want to really come against it with all the moral authority that we can. And when I speak about the timeline of how we got to this point and how the Palestinians, how it's part of an agenda that's been with us for about 2 decades now. The Palestinians have been working on the International Court during this time, and they've had some good progress with this chief prosecutor, Fatou Bensouda, during her term. And they first managed to convince her in January of 2015 at the Palestinian request to open a preliminary examination of the situation in, quote, Palestine. And on December 20th, 2019, there's a lot of other things on her plate as chief prosecutor, but they took their time, were fed information, all sort of, the Palestinians were really able to lobby and get the information in. Bensouda announced December of 2019 that there was a reasonable basis for opening an investigation into the situation in Palestine. January 20th, this would have been about a year ago, a pretrial panel of judges rejected the chief prosecutor's initial request to examine this issue based on a technical issue. Her 110-page brief was too long. And they told her to whittle it down some. Within a couple months, April 30th, 2020, she had resubmitted it as only 60 pages. They said, okay, and have been proceeding from there. Just within a month, the ICC had asked the Palestinian Authority for a clarification on PA President Mahmoud Abbas's statement that the Palestinian Authority would no longer be bound by or abide by the Oslo agreements. And they wanted to clarify. Of course, Abbas had said that many times, but this time he really meant it. And the court at this stage in the process said, can you clarify this for us? And you can see there's been this Israel's been on the sideline watching all this, but a direct dialogue with the Palestinian Authority over this whole probe, this whole effort. And on June 5th, the Palestinian Authority clarified that it regarded itself as absolved of all agreements with Israel, including Oslo, but it did not deem this to affect the case that they were trying to build before the court. A few days later, June 8th, the chief prosecutor, Bensouda, agreed that Mahmoud Abbas's declaration about not being bound by Oslo had no influence on the status of Palestine as a member of the Rome Statute, so they could proceed. And then on February 5th, just a couple weeks ago, this pretrial panel of judges ruled that the ICC did in fact have jurisdictional authority over the territories occupied in 67, including Gaza, West Bank, East Jerusalem. And this is where we are today. But you see that steady dialogue between the ICC and the Palestinians that have led us to this moment. And today we're trying to get a little more knowledge background. What are the weaknesses in the Palestinian case? How can we help? But it's really outrageous for us that once again, the laws and norms, Geneva Conventions, other things set up after World War II to try and deal with some of the atrocities committed against the Jews in the Holocaust, that they are now being used as a club against the Jewish state. And we want to be clear that war crimes, crimes against humanity, genocide, these are especially heinous violations of law and moral decency. In fact, they're so bad, so odious, that there are no statute of limitations for prosecuting them. And thus, we have seen in modern times Nazi war criminals hunted down to their grave by the Simon Wiesenthal Center and others for a decade. I live in a neighborhood here in Jerusalem where I see my friend Ephraim Zuroff every day going to prayer at synagogue, and he's considered like the last Nazi hunter, one of the last ones, and he's still 70 some years later trying to find some of these guys. But when you're talking about war crimes, crimes against humanity, they're so bad that there should be no limit on how long you can hunt these people down. But now the ICC would have us accept this perverse moral equivalence between what the Nazis did in forcefully transporting millions of Jews to their deaths and the voluntary return of Jews to the heart of their ancient biblical homeland, including Jerusalem. It's unacceptable in our view. And over coming months, the ICEJ is going to work with Israeli authorities, with other respected organizations, with our global network and family of branches and activists around the world to oppose this and get our nations to reject and rescind this outrageous decision. Thank you, and thank you to our guest panelists for joining us today. Thank you.
Thank you, David. Thank you for this clear presentation. And it is indeed a perversion, and it just satisfies one clear pattern when it comes to anti-Semitism in history. Whenever the international community considers something as the most heinous crime, and genocide would fulfill this criterion, then inevitably anti-Semite ascribe these most horrible crimes to the Jews. And this is what we are seeing vis-a-vis the only Jewish state applied by bodies like the ICC. Before we give the floor to hear Israel's point of view, I would just like to recognize a few panelists who are among us. I can see Dr. Jacques Gauthier from Canada, respected lawyer, and one that has taken stand for Israel many times. It's great to have you, Doctor, and you will have opportunity to join later with your comments. And I would also like to recognize Mr. Christoph Scharnweber from Germany, our top activist in the country of Germany, one of those 7 countries which actually filed a clear statement to the pretrial chamber, which was later ignored, but is one of the state parties which shares the view which is being expressed today. Mr. Andrew Tucker, who is a lawyer originally from Australia. He now lives in the Netherlands. He is an attorney specializing in international law and a respected Christian advocate for Israel. He speaks on behalf of a Christian think tank called THINK, which is an abbreviation for the Hague Initiative for International Cooperation. It is an organization dedicated to the promotion of the rule of law in international relations. And their focus is clearly the conflict between Israel and the Palestinians. And as has been said, Andrew is very well informed about the whole case. So I would ask you, Andrew, to take the floor and give us your insights.
Thank you. Thank you so much, Moimir. Thank you, David. Thank you, Amit, and for taking initiative to organize this event, and thank everybody for participating. I think it is extremely important and very valuable that those of you in different countries around the world really grapple with what is going on here. I fully agree with the previous speakers that this is a fundamentally important decision. We've seen a lot of things over the last couple of decades, and there's always those critical points in history, aren't there, where major decisions are taken, and I believe this is one of them. I'd like to just take a little bit of a step back, if you like, and think about some of the bigger issues that are raised by the decision. I think David and Amit have explained extremely well what was decided, and I think the key legal issues that are raised. First of all, I think the fact that this took a year for the courts to come out with this ruling is in itself significant. And as Amit mentioned, it's a ruling by 2 of the 3 judges. And there's a very significant and substantive minority opinion being issued by the Hungarian judge, Peter Kovac, which raises a whole bunch of issues. And I think many of them offer interesting, not only lines of argument, but I think fundamental positions which we can use later as we think about how to raise arguments about this and to whom can we raise those arguments. There are three, I think, levels at which we can sort of think about this decision, and I'll touch on a number of them. One is the very technical legal analysis of the decision. Was it a right or was it wrong? Did they get the analysis of Article 12.3 of the Rome Statute right? We can have arguments about that. I think they got it fundamentally wrong by deciding that when the Rome Statute talks about a state, it simply means a state party. And in their view, any entity that accedes to the Rome Statute becomes a state party and therefore is a state in the terms of the statute. I think there's an illogical reasoning there at a technical level. Secondly, there's a more strategic level to this decision, which I think is the level we probably need to think about. And there's also some very fundamental conceptual issues. Now, I've got five points just to touch on, and I think will help us perhaps a little bit. First of all, this whole issue of statehood. Now, really what you have, and I think you see it very much in the majority as opposed to the minority view. The majority is a French judge and an African judge taking a view about statehood. They say we don't need to look at the issue of international law. We simply decide that if the General Assembly has decided this is a state, then that's good enough for us. And to be honest, I can understand this line of reasoning. If I were in the court, I don't think I would want the court to be getting into this hot potato of whether this thing called Palestine is or is not a state. The court was confronted with, I think, over 50 by leading international.
I'm afraid we have some problems with the connection. Let's hope that Andrew comes back soon. His line is not working at the moment. Yes, right, Andrew. I think that we lost you, but I see you're back. So we give the floor back to you, and please continue with your presentation.
Okay, thank you so much. I'm terribly sorry about that. So the point I'm making is actually about these mindsets, and this point I think we need to stress is we have two very fundamental worldviews going on here. There's the worldview of the international criminal arena that, and we see this in the judgment where the court says the purpose of the Rome Statute is to end impunity for international crimes. If we think there's a crime out there, then we will interpret the statute in such a way that we can tackle that crime. The prosecutor thinks there are crimes being committed by Israelis and Palestinians. Therefore, the court says we interpret the statute in such a way that we give ourselves jurisdiction. And I think this reflects this very dominant line of thinking in international legal world of the international criminal lawyers. And international criminal law and human rights law has become the fundamental paradigm today through which, the lens through which people look at the world. And unfortunately, they see Israel as being the perpetrator and the Palestinians as the victim. And this is the most difficult paradigm we have, I think, to change, to bring in the sense that the world is not made up of perpetrators and victims. This is a complex dispute. The Middle East is complex, this dispute is complex, and it's about two peoples having different perspectives, fighting or arguing about a piece of land and authority and sovereignty and so forth. So these two worldviews, I think, are problematic. And one of the things that I think that is important to be argued is the case that the minority judge Kovac does. He says sovereignty is important, statehood is important, and the responsibility of states, not only their accountability, but also the responsibility of states is important. And that is the reason that he goes right into the question of whether or not Palestine is a state or not. That leads to my second point, is that the court really simply ignores the position of Israel. It says this is just a dispute between Israel and the Palestinians about borders, and their reasoning is that our decision does not affect that dispute because we're not making a decision about borders. Therefore, we're not interfering with the sovereignty of Israel. Now, I think that's fundamentally wrong because necessarily this decision, if not directly, then indirectly, it's going to have a normative influence and effect on people. They will see and they will be confirmed in their perspective that Israel's legitimacy is limited to the so-called 1967 lines, which for many reasons is fundamentally wrong. So at that level, I think the court has got this wrong, and there's a real issue here about undermining Israel's right to territorial sovereignty, its right to equality in the international legal order. I think thirdly, perhaps most fundamentally, is the question about how we look at the territories. And I believe this is the core as well of this decision. It's about how we frame the way we look at the territories. And again, the court sees these territories, everything outside the Green Line, as effectively belonging to the Palestinians. They say Palestine may not be a state fully according to international law. Nevertheless, implicitly, the Palestinians have a right to statehood over all of those territories. Now, this, I think, is also a fundamentally incorrect framing of the issues. Unfortunately, it is the majority view out there in the international legal world. Most international lawyers, and we saw it when the annexation issue flared up in the middle of last year, hundreds of prominent international lawyers putting up their hand and saying Israel has no rights to sovereignty outside the Green Line. Now, the Judge Kovac, the minority judge, takes a different view, and he says, this is the reason why he says the Oslo agreements are so important, because they reflect the fact that these are disputed territories. Israel's sovereignty and the sovereignty of the territories has not been determined. No international tribunal, not even the International Court of Justice, has made a determination about where sovereignty lies. This is the view that Israel has put and tried to put strongly, and I believe other states need to confirm that sovereignty is still to be determined over these territories. And the reason the Oslo Accords are so important, or one of the reasons, is that it creates a process for that fundamental issue, amongst others, to be determined. And the only way it can be determined is through the negotiating process of the parties. Which leads to, I think, an issue about negotiations. I think a lot of work needs to be done still to explain why negotiations are so important and necessary, also legally speaking. I don't believe this has necessarily been explained or understood well enough. Israel's position, and in fact the international community's position, is that the only way that Palestinian statehood can be achieved is through negotiations. Now, if that's true, if negotiations are required under international law, then that means that both parties, Israel and the Palestinians, need to be respected in their positions and not be, and parameters not imposed upon them, which is effectively what this kind of decision is doing. So I believe going forward, one of the discussions that needs to be had is about why negotiation is important. And one of the reasons it is important is because sovereignty has not been determined, at least as far as the West Bank is concerned, outside Jerusalem. Let me move just to To the point then of settlements, and this raises the issue of Jerusalem as well. There are two kinds of war crimes that the prosecutor believes that have been committed. One of the war crimes related to the Gaza conflicts. Since 2014, the court potentially has the right to investigate those crimes by Israelis and, according to the prosecutor, Hamas leaders as well. The other set of crimes relates to settlements, or so-called settlements. She believes that these settlements are illegal, or at least Israeli policy to enable the settlements to be created is a war crime. The fact that she believes that is used by the court to justify granting itself jurisdiction. Now, we have to realize settlements is one of the provisions of the Rome Statute. It comes from the Fourth Geneva Convention. It's the crime of deporting or transferring the population of the occupying power into the occupied territories. This provision has never been the subject of any proceedings anywhere in the world. The court is getting itself into an area here which is not only legally but factually extremely complicated, has never been the subject of international proceedings. But I believe this is really what the prosecutor wants to get her hands onto, and which she sees as being perhaps even the most fundamental war crime in her view. There is a distinction to be made between Jerusalem, or so-called East Jerusalem, and the West Bank, the reason being that Israel has clearly asserted its sovereignty over East Jerusalem since 1967. The international community has never accepted that, but Israel has a much stronger position there to say that it has sovereignty over East Jerusalem. I think that needs to be argued and needs to be articulated because it has control, and it has clearly, through its application of Israeli law and jurisdiction to East Jerusalem, asserted its sovereign rights. The West Bank is more complicated because Israel has not taken that position. Therefore, it is going to be more difficult for Israel or others to claim that these are not occupied territories, or that the settlements are somehow illegal. The court will have to, if it moves down this line, explain the elements of the crime, which I say are legally complex, and there will be an enormous factual issues about proving that specific settlements have involved deporting or transferring Israeli civilians into the territories. As we know, all Israelis living there are doing so voluntarily. They've not been forced by the state of Israel or anybody else to live there. So there's a whole bunch of issues there which I think the court is going to have difficulties with. Leads me to my final point, that is really going forward. The question now is, what will the prosecutor do? We have a new prosecutor who will come in June. It's the British international criminal lawyer, Karim Khan. He is a leading light in international criminal law. He has his own persona, he has his own view of things. He will take a fresh look at this. One of the issues that will be discussed is whether this decision means that the prosecutor is obliged to proceed with an investigation. I don't believe so. I think this prosecutor will have the discretion to decide. The court is under enormous pressure. Again, an important point, I think, to realize. The court has failed fundamentally in its mandate over the last 20 years. Many states are dissatisfied with the courts. The state's parties have subjected it to a review. So this new prosecutor will be under a lot of pressure to settle priorities. And I think the argument needs to be made that this, certainly the settlement issue, is not an area that the court should be getting itself into. There are much more fundamentally problematic war crimes that the court should be dealing with. My final point is, I think the state parties, one of the points the court made was, it's the state parties who accepted Palestine into the UN as a non-member state. It's the ICC state parties which accepted its accession to the ICC, and there's an implicit criticism of the state parties. I think it's a justified one, that really states are not, if they don't believe Palestine is a state, then they shouldn't be allowing Palestine to be getting to this position. And therefore, I think a discussion needs to be had within the Assembly of State Parties. And as we've seen, a number of states have already said they're not happy with what is happening, that pressure is put on the prosecutor and potentially even the legal process from within the Assembly of State Parties to challenge the decision. So this is just the beginning, I think, of a very long road, and I think there are many opportunities for challenging what is a very problematic decision. Thank you.
Thank you, Andrew. We already have a few panelists who would like to add the comments. Christoph Scharnweber from Germany would like to make a point. Christoph?
Thank you very much also for organizing this meeting. I have a question concerning the role of the countries that now express that they do not agree, like Germany did. I mean, the German foreign policy originally declared that we fully trust the court, what will be done. Now they changed. We are very happy about this. They say we do not agree. So this is really a miracle. And the question is, if now these so-called friends of courts, amicus curiae, are asked about their opinion, is this just something very polite? Everybody can express something, but things will go on as the court wants it? Or does it really has an influence? And the second question is, if the chief prosecutor is changing in June, then can be done something pragmatically so that the whole trial and the beginning of the trial can be postponed. I mean, whoever is a lawyer here in this meeting understands that you can do a lot of things sometimes so that the trial does not start, and a lot of things are discussed before. So what would be a pragmatic solution so that this trial against Israeli soldiers cannot start? I mean, we all can agree that we do not like what the ICC does, but this doesn't change a lot. So what can be really done, and what can our countries done, or is there something we can do in order to lobby in our countries for that case?
Thank you, Christoph. Very relevant. I would field the question to Andrew. Probably.
Thank you. Thank you. A very, very good question. The first question about the friends of the court. When the court opened up for people to make submissions, they gave the opportunity to states and to others. Now, it was, as Amit says, quite remarkable that 7 states made a submission, and they are all also state parties, so they have a very different position. I think this is really where the focus should be now. The academics or the NGOs that made submissions, the court has really basically ignored them. Well, they haven't ignored them, they've adopted the view of half of them. And they've failed to fundamentally engage with the arguments of the others, which were good arguments. They were substantive arguments, but the court really has ignored them. And there's no process for them now to get back involved in the decision. So therefore, I think the opportunity is for the state parties like Germany, like Austria, Hungary, the Czech Republic, also Australia, Brazil, Uganda. These are the states which I think need to be lobbied, I think, in a positive sense, and they need to be encouraged to be taking a proactive view and getting other states around them to, I think, challenge the decision and convince the new prosecutor, because as has been said, he has to establish the new priorities. And to convince him that certainly going down this route is not going to be a helpful way of proceeding.
Thank you, Andrew. So if I may just repeat that, we do have, or the state parties do have a legal way that they can do, and we have representatives in those countries, so we can do well to lobby them and to make our voices heard. Then we also have probably another way to make our voices heard in a more general sense. And I have heard a lot of questions here about what can we do to educate our people and to give them a possibility to join a campaign or something. So this is one of the things that we are considering. We'll come later to it. And this is something that we can invite all of you to take part in. Before doing so, I have another question from our Finnish representative, Jani Salokangas. Jani, would you please ask your question?
Yes, thank you so much for the panelists. It's been very informative. Also for a lot of people who are not very aware on the basics of this issue. I just have a question regarding the interpretation of international law and the boundaries of the international law, because as I understand right now, the ICC is stretching its jurisdiction over areas that actually has no jurisdiction over. Because looking at the situation, for example, in Cyprus and Turkey, Cyprus is a member of the ICC and Turkey is not a member state. So looking at this case, I would say that the ICC has a much stronger case to actually rule against Turkey and put people of the Turkish regime under international law. So my question is, what does this do actually to the value of international law when the actual entity who is supposed to be working inside of the international law is not really valuing the law that they're supposed to be representing?
A question on international law, I think I would ask Andrew again, being an expert in that area.
Sorry, it's a very good question. Thank you. The problem is international law is, in a sense, what you make of it. A lot of people are actually saying this is actually a very good development of international law. The international community should be accepting less than state parties. There's a very strong line of thinking out there that we should get away from sovereign states, and we should be opening up the international community to entities like Palestine, which are less than states. So they would see this as being an affirmation of international law. So really it's a discussion between two different views of international law. And I think our job is to articulate the reasons why states are important and why a traditional or conservative view of statehood is important, and that it underlies the ICC, which has no power, no jurisdiction, no authority to do anything except that states give to it. And that's an argument that needs to be made very strongly. So I agree there's a very big difference between the Cyprus case and this case, for the very reason Palestine here is, universally understood not to be a state yet. It aspires to be a state. Everybody wants it to be a state, apparently. A lot of people do, but it's not one yet. And we need to articulate why that's important.
Mormir, I would add there's an old adage in the legal profession that bad cases make bad law, and I think this has been a truth in the Israeli-Palestinian conflict for decades, that the way the anti-Israel elements out there have tried to bend and shape and manipulate international law to put Israel in the docket time after time after time, it's actually undermined universal human rights laws, universal criminal laws, and all of these things in a way that is very unfortunate for the whole world community.
Yeah,
May I add one more point?
Sure.
I think that the answer is actually simple to this question, because this decision of the court completely distorts international law. And as was said by Andrew, the court can judge only country states that are member of the Rome Convention, and Israel is not a party to the ICC, and it has not consented to its jurisdiction. Only sovereign states can delegate jurisdiction to this court, and there is no Palestinian state. And thus, with this ruling, this court becomes a political tool and not any form of institution that makes justice. And I want to add one more thing, and to say that last week in our synagogues, we read in the Torah portion of Mishpatim. It's Exodus 21 to 24, and this Torah portion begins with the words of God that were directed to Moses. These are the Mishpatim, these are the laws that you shall set before them. And basically this is the continuation of the 10 commandments. And when you look at the operation of this court, you see that justice and this, the ruling of this court are completely apart. There's no justice. It is only a political tool, and thus it completely distorts international law. One more thing that has to be said again is that this court was established in order to confront mass atrocities that really deeply shock the conscience of the entire humanity. And it was not established in order to pursue democratic states that are completely committed to the rule of law. So this is my 2 cents on this.
Excellent, Sharon. Well, we are coming to a close of our session, and I think there's a universal agreement among us that the decision of the law of the ICC is deeply flawed. Now the question needs to be said, what can we do about it? What can we do? We are here representing a global network of activists. Some of our lawyers, some of us are lawyers, some of us are people who have access to politicians. So what courses of action can be considered in order to try and prevent, first of all, the investigation, or what kind of influence can the public have, in fact, or through the member states? What is the possibility that we could possibly do? Anyone?
I think the time has, may I? I think the time has come where we need to really up the game when it comes to the public relations, because Israel has been standing on international law since 1948. And people aren't listening. Too many people aren't listening. When you look at the reputation of these organizations, like the United Nations, like the International Court, it's deplorable. And perhaps it's time for each one of us that's here to start talking to, ministering, being able to get out the message to our sphere of influence, and taking it very seriously and taking it to the next level to educate people so that Israel is given a fair shake when it comes to information, public relations. The slander against Israel is why we're here today. The other side, the entire Palestinian Jihad, they're not standing on anything solid. And the Palestinian Authority keeps boasting, even on PATV for children to see, that the Palestinian culture is one of martyrdom. And Israel needs to become, I think people, all of us, more engaged in that kind of an activism when it comes to truth, recognizing that it's Israel, but it's also all democratic nations, because Israel is really the only democracy in the Middle East.
Thank you.
Moimir, can I make a suggestion, Moimir?
Yes, please.
As you know, our turf is the international law, but is now an urgent matter, and it has been said by several speakers. There may be a window of opportunity where we, as individuals living in the democracies we live in, have access to the representatives in parliament and in the government, be it opposition or be it in the coalition. But we should talk to our representatives in the parliaments and say, what the ICC is doing is not according to its original charter. This is not why it was established. And now it's moving, taking political decisions and going in the wrong direction. And we don't have to be emotional about it, but it is not in the interest of our democracies and the ICC itself if it continues on this path. So maybe next week, when we have the next edition of the conference, we can phrase some actions that will enable the audience to take action in their countries.
Yes, Peter, exactly. I believe that there are basically two avenues which seem to be available to us. One is to present our elected officials, our governments, with clear-cut arguments. This is where our lawyers can help us formulate and give argumentation with which we can address these people and try to convince them to exert their influence within their sphere of influence towards the ICC. And the other thing that I can see, there is a widespread call for education. And this is, I believe, the role of the ICJ with our global network of activists. And we have already considered perhaps starting a global petition which would activate people. And in the wake of that petition, we would also provide some basic information which could be shared and with which people could educate their communities, their churches, leaders, and so forth. So this seems to be the two paths that we can take simultaneously, using the body of arguments in these two-way, political and let's say social or global. And we are going to do our homework and bring some concrete proposals to you next week. So stay tuned with us, and also you can talk to your friends and people who could make a difference in this matter and invite them to join us next week. I will give the final floor to David if he would like to wrap up the discussion today.
Yes, we want to invite everyone to come back during this same time slot next Thursday for part 2 of this webinar series on the ICC ruling, where we're going to talk about what we can do within our own countries and together as a worldwide movement, teaming up with other organizations. We'll have a whole new set of panelists to do this, but this was an educational background context, very good presentations by the fellow panelists. We want to thank y'all again. And next week, we're going to talk about call to action, what we can be doing, and try and have some materials ready at that time for people to equip them and mobilize them in this battle. It's a case of the enemy isn't sleeping, and we have to stay at the wheel ourselves, our hands to the plow. But we have a God who neither slumbers nor sleep, who watches over Israel. So we don't have to fret about it, but we have to do our moral duty towards Israel and the Jewish people and state in defending them from things that Christians used to do to them and that are now considered atrocities and criminal offenses. And we know Israel does not belong in that category now. Okay.
Yes. Thank you, David. Once again, thank you all our panelists, Amit, Andrew, and David. Thank you to all of you who participated actively. Thank you. We had almost 128 participants at the height of the session. Just for your information, it has been recorded. It will be available on YouTube and I believe also on Facebook. So you have this recording also available to you later on. And again, if you have any particular specific points, you can send it to us in the meantime. And next week on Thursday, we're going to present some specific proposals hopefully we can move the thing forward in our common effort. So thank you very much. God bless you. See you next week.